I want to present my my work, result of my research, and I hope it will be very interesting for you. Yes. I have a topic on which is entitled "Marriage of East African Foreigners Celebrated in Rwanda." What does Rwandan law say? I'm going to explain if how a foreigner, an East African foreigners can have their right to marriage according to East African laws, according to Rwandan laws, according to Congolese laws, South Sudanese laws, so and so on. So, the Constitution of the Republic of Rwanda, as revised, of Rwanda of 23, as revised in 2015 and published in official gazette number special of 44 December 2015, states how is the hierarchy of laws. Its article 95 states the hierarchy of laws is as follows: first, constitution; second, organic law; third, international treaties and agreements ratified by Rwanda; fourth, ordinary law; fifth, orders. A law, which means here we have to understand more what is the meaning of hierarchy. Hierarchy means the superiority. What is the superiority of a law according to another, toward to another? Here, constitution is a law which is higher than organic law, while organic law is a law which is higher than international treaty, and international treaty is higher than ordinary law, while ordinary law is higher than orders, ministerial order, presidential order, yes, and the other orders. A law cannot contradict another law that is higher in hierarchy. We understood that. Organic laws are those designated or designated as such and empowered by this constitution to regulate other key matters in the place of the constitution. Law, family law of 2016 governing persons and the family, as published in official gazette of December of 12 September 2016, is one of Rwandan organic laws. By hierarchy is the second. After constitution is the second law, which is very important. First is there is constitution. Second, there is organic law. They continue. This law states in its article 179 on marriage age of foreigners. Marriage age of foreigners, in the first paragraph, I see. In its chapter 2, between brackets, marriage of foreigners celebrated in Rwanda, it states the marriage between foreigners celebrated in Rwanda is governed, first, with regard to marriage celebration by the Rwandan law; second, with regard to substantive requirements by the national law of each of the spouses. By the national law, we have to understand, by the national law of each of the spouses. You are a foreigner, you are not a foreigner, you are a refugee, you are a foreigner, which is not, who is not refugee, or you are a foreigner who is refugee. In all circumstances, if you are only a foreigner, remember that a foreigner is those persons who live in a country which is not their homeland, which is a country with another citizenship, which, yes, by the national law of each spouses, with regard to the substantive requirement by the national law of each of the spouses. Substantive requirements, there are, for example, age of majority, age required to get married. Yes. If they continue, if it does not contravene public order and the good morals of Rwandans, we have to understand that Rwandan law accept that foreigners, if they are refugees or not, non-refugees, no problem, they accept that foreigners continue to enjoy their private right, but in respect of local right, national right, Rwandan rights, Rwandan public order and the good morals. Now we are going. We continue. There is another paragraph, but after this article, we are going to see together. What is public order? What are good morals in order to, so that we will understand more if there is a public order crime or there is public order respect. If a foreigner, if a refugee from Burundi, from South Sudan, from Kenya, from Uganda, from Tanzania is in Rwanda and is searching for foreigner rights, for his private right to get married legally in respect to his or her domicile law, because Rwandan law is clear on the right of private persons. So the marriage between foreigners celebrated in Rwanda is governed with regard to the marriage of celebration by the Rwandan law. I read this article. 2. With regard to substantive requirement by the national law of each of the spouses, if it does not contravene public order and the good morals of Rwandans. 5. With regard to the matrimonial rights of each person and the right of children, when there is no common agreement by the law of the country where they reside. 4th, with regard to the effects of marital property, when there is no marital property agreement by the law of the country where the property is located, the same law continues to state in its article 113 on age of majority. The age of majority is 18. Years unless provided otherwise by this law or other laws. A law having attained that age is fully qualified for all acts involving civil life. So, what is public order? What is What is public order? Yes, we're going to see together what is public order, what are good morals, what is public order, what is public order. According to the Open University and the Metropolitan Police Authority 29, in its center of its center of international center for the history of crime, policing, and justice. In its introduction of the article entitled Police and Public Order, it is stated, I read, what is public order? This is not a question that is easy to answer. In a sense, you might respond by saying that public order is essentially the absence of disorder, the quiet and orderly behavior of people in public space. Full stop. I continue. It involves people behaving sensibly and rationally and respecting others. Full stop. I continue to read what is written on the website. The problem is, it is not me who has written this. The problem is that one person's exuberance on the street often constitutes an annoyance to another. I close the brackets. So, I think that public order is, I think you can think, another one can think. I think that public order is when there is no widespread criminal and political violence, such as kidnapping, murder, riots, arson, and intimidation against targeted groups or individuals. Also, to act against a public order is a crime. Yes, I understand, you understand. When you do what is against the public order, you are committing a crime. Yes. So, but, what is public order crime? If you do what is against public order, you commit a crime. If you do what is against good morals, you commit a crime. So, what is a public order crime here? In criminology, I read, because I've done research, and I told, there are results of my research. In criminology, public order crime is defined by Siegel 24 as crime which involves acts that interfere with the operations of society and the ability of people to function efficiently. For example, it is behavior that has been labeled criminal because it is contrary to shared norms, is related to the act, you understand? Social values and customs. Understand that public order crime is each act which is against the law, in a few words. So another author, another researcher, another person written this. Robert Stone is another person, maintains that a crime is nothing more than an act that contravenes a law. An act that contravenes a law. Here I'm very I agree with him. Act that contravenes a law, which is contrary to a law. Yes. Generally speaking, deviance, dévier, qui peut dévier, la déviation. Deviance is criminalized when there is too disruptive and has proved uncontrollable through informal sanctions. So this was A. B. What do good morals mean? Those are some of all values frequently listed: acceptance, charity, compassion, cooperation, courage, dependability, due regard to the feelings, rights, traditions, and the wishes of others, empathy, equality, fairness, fidelity, forgiveness, generosity, giving pleasure, good sportsmanship, gratitude, hard work, ability, humility. Now we have more knowledge about public order, good moral. So suppose that there are foreigners who are refugees in Rwanda. We want to read more about refugee rights. We have a convention writing two status of refugee, which means we have an international treaty on refugee. The convention relating to the status of refugees as adopted on 2018 July 1, 1951 by the United Nations Conference of Plenipotentiaries on the status of refugees and stateless persons, convened in the General Assembly Resolution 429 of 4th December 1950. Its entry into force happened on 22 April 1954 in accordance with Article 43, is one of international treaties Rwanda ratified and states in its Article 12 on juridical status, private life, or a refugee or its personal status, that one paragraph, we have two main paragraphs. One paragraph, the personal status of a refugee shall be governed by the law of the country of his domicile. I repeat again, the personal status of a refugee shall be governed by the law of the country of his domicile, or if he has no domicile, we remember that all Burundians living in Rwanda has their domicile is Burundi, or Congolese refugees living in Rwanda, they have their domicile, which is DRC Congo. if he has no domicile by the law of the country of his residence. The country of refugee of residence of refugees in Rwanda is Rwanda. So the country of residence is Rwanda if those refugees don't have their exact accurate domicile. Second paragraph. This is first paragraph is very important. The second paragraph, rights previously acquired by a refugee or dependent on a personal status, more particularly rights attaching to marriage, which means if I'm Burundian, if I'm Congolese, if I'm South Sudan, I have right to get married when I will have the age required to get married. Which means that if I'm a foreigner, I'm Burundian, I'm Congolese, I'm Kenya, I'm from Kenya, I stay with I remain with my private rights. I can be refugee. I cannot be refugee, but as a foreigner only, I stay with my private rights. Which means you are a refugee, you stay with your rights of, if you are a Burundian, you are a refugee, but you stay with your right, your private rights that you had before being refugee. Yes, paragraph 2. Rights previously acquired by refugee and dependent on a personal status, more particularly rights attaching to marriage, shall be respected by a contracting state, subjected to compliance if it be necessary with the formalities required by the law of that state, provided that the right in question is one which would have been recognized by the law of that state had he not become a refugee. Which means you keep your right you had before being a refugee, which means your private right you had when you were not a refugee are always the same right you have even if you became a refugee. It's clear. We are going to read a decree or an order which is not higher than organic law. So which is not higher than international treaty. It is a very low, low number law of 21st in May 24 for 20 relating to refugees as was published in official gazette number of 24 that stated President Kagame, the Parliament, the President of the Republic, the Parliament has adopted and we sanction, promulgate the following law and order it be published in the official gazette of the Republic of Rwanda, the Chamber of Deputies, the Senate, pursuant to the Constitution of the Republic of Rwanda of June 23 as amended to date, especially article on pursuant to the Convention on Diplomatic Relations signed at Vienna in April 1961, to which Rwanda accessed by the law of February 1964, pursuant to the convention relating to the status of refugees signed in Geneva on 28 July 1951, to which Rwanda accessed by decree law of 22 October 1979, or confirmed by law of 26 January 1982, pursuant to the protocol of 21st January 1979 1967 relating to the status of refugees to which Rwanda accessed by decree law of 22 October 1979, confirmed by law of 26 January 1982, pursuant to the Organization of African Unity Convention of 10 September 1969 governing the specific aspects of refugee problems in Africa, to which Rwanda accessed by decree law of 22 October 1979, confirmed by law of 26 January 1982, pursuant to organic law of 25 July 28 relating to Rwandan nationality, having revealed law of 5 July 21 relating to refugees as modified and complemented to date adopts chapter 1. There are many chapters. Chapter 1, General Provisions, Article 1, Purpose of this law. This law governs refugees and asylum seekers in Rwanda. Article 2, Definitions of terms. There are many terms, but now we are going to know more about the meaning, the definition of refugee as one of many terms. For the purpose of this law, the following terms shall have the following meanings. First, refugee. We are going to take one term. Refugee is a person who has been granted asylum in accordance with this law and international instruments relating to the status of refugees ratified by Rwanda. And Article 12 on marriage of refugees states that the marriage of refugees shall be governed by Rwandan laws, which means constitution, organic law, international treaty, so and so on. We are going to verify, to check if all those Rwandan laws are respected. Documents required for marriage of a refugee shall be issued by a civil status registrar whose jurisdiction covers the place of settlement of the refugee on the basis of information and documents availed by the organ responsible for the daily management of refugees. When a refugee is married to a Rwandan, he or she shall keep his refugee status unless he or she acquires Rwandan nationality in accordance with relevant laws. This is not very important for me. What is very important for me is to know that the marriage of refugees shall be governed by Rwandan laws. Rwandan laws, which means organic law, international treaty, and we saw that as organic law, family laws governing family and persons is one of organic laws, and convention related to status of refugees is one of international treaty. Yes, we are going to respect the hierarchy of laws. The case of Burundians. Selon la loi burundaise, pour fonder la famille nucléaire restreinte légalement, il faut 2 personnes adultes, filles d'au moins 18 ans et garçons d'au moins 21 ans, et 2 témoins adultes marraines côté filles et 2 côté adultes parrains côté garçons. Selon le décret roi numéro 1 024 du 28 avril 1993, c'était lors du Ananique 3, vous vous rappelez, portant réforme du code des personnes et de la famille. Dans son article numéro 88, il a stipulé que l'homme avant 21 ans révolus et la femme avant 18 ans révolus ne peuvent contracter mariage. Ça veut dire qu'ils vont contracter mariage dès qu'ils atteignent les 18 ans révolus. Donc, avoir les 18 ans. Néanmoins, le gouverneur de province peut accorder dispense d'âge pour motif grave. Hein? Il y a des filles qui mettent au monde des enfants et qui vraiment veulent vivre avec leur mari. Et des fois, il y a cette exception qui peut être appliquée pour que une fille soit accordée une autorisation officielle de fonder une famille de façon légale avec son mari, avec qui elle a avec qui elle a dormi, s'est rencontrée. Voilà. In other words, in English, I would say the man before the age of 21 and the woman before the age of 18 may not enter into marriage. Second, the case of Congolese. Yes. Law. La loi du 16 juillet 2016 modifiant et complétant la loi numéro 097-13-010 du 1er août 1987 portant code de la famille stipule dans son article 352 que l'homme et la femme avant 18 ans révolus ne peuvent contracter mariage. C'est comme le Burundi. La Congo et le Burundi, c'est le même. In English, I would say a man and a woman who have not attained the age of 18 years may not enter into marriage. Article 357 explique même les limites de l'émancipation en droit que l'enfant, même émancipé, ne peut contracter mariage. Nous l'avons vu, nous savons comme l'émancipation, pour faire l'émancipation, tu peux avoir le droit d'avoir à titre légal les biens ou les propriétés de ses parents quand ton père ou ta mère ont décédé. Tu as 16 ans, on va faire l'émancipation, même si tu es déjà émancipé avec le droit d'avoir des biens ou la richesse de ton père ou de ta mère. L'État a voulu que tu émancipes, a voulu que tu sois un peu adulte, mais tu ne peux pas te marier. Ça, c'est normal, au Rwanda, en Tanzanie, plutôt au Rwanda, au Burundi, en Tanzanie, c'est bien, c'est comme ça. Voilà. 3. The case of South Sudanese. Currently, there is no one specific statutory law governing marriage and divorce in South Sudan. The constitution recognizes the customary laws and the traditions of over 80 South Sudanese ethnic groups as governing personal matters, including marriage and divorce for their members. According to the transitional constitution of the Republic of South Sudan 2011, it is right. The sources of legislation in South Sudan shall be this constitution. That is the one written law is only constitution in South Sudan. So A, this constitution. B, customs and the traditions of the people. C, the will of the people. And D, any other relevant source. Also, in its Article 15 of the right to found a family, it is written, every person of marriageable age shall have the right to marry a person of the opposite sex and to found a family according to their respective family laws, and no marriage shall be entered into without the free and full consent of the man and the woman intending to marry. 4. The case of the Tanzanians. What is about Tanzanian law on family, on marriage celebration? Law of Marriage Act, chapter 29 in legislation as at 30 November 2019, the law states on a minimum age of marriage, Article 13, first paragraph or first sentence, that no person shall marry who, being male, has not attained the apparent age of 18 years, or being female, has not attained the apparent age of 15 years. 5. The case of Kenyans. In the Kenya Marriage Act 2014, number 4 of 2014 of 19th April 2014, number 4, law states in its article number 4 on minimum age of marriage that a person shall not marry unless that person has attained the age of 18 years. 6. The case of Ugandans. The Uganda Marriage Act of 2014 states in its Article 10, Sub-Article B, that the marriage is legally celebrated if each of the parties to the intended marriage, not being a widower or widow, is 21 years old, or that if he or she is in that age, the consent hereafter made requisite has been obtained in writing and is annexed to the affidavit. So now I have my view, I have my point of view, what I think, what is my position about the marriage of East African foreigners celebrated in Rwanda. I'm going to publish other videos and articles on marriage celebrated in Uganda, marriage celebrated in Tanzania, marriage celebrated in Burundi, Kenya, Tanzania, so and so on. So, I am trying to explain or interpret Article 12 of the Geneva Convention relating to the status of refugees ratified by Rwanda. Suppose that those foreigners, those East African foreigners are refugees, for example. The private rights of a foreigner living in Rwanda are the same as the private rights of foreigner refugees living in Rwanda. Second, the rights of refugees are the same as those the same refugees would have if they were not refugees in the foreign country in which they would be living. You have to pay attention on this point. Foreigners keep their rights that they would have if they were still in their country of origin, if they were at home, if they were on their homeland, in other words. So who are accepted by Rwandan law for the celebration of their legal marriage on Rwandan soil? So who are accepted? By Rwandan law for the celebration of their legal marriage on Rwandan soil? According to my research, you can do your own research. Now this is my research. Yes. Yes. According to my research, I find that first, Burundians who are already 18 years old should be accepted to celebrate their marriage in Rwanda, whether or not they are refugees in Rwanda, as Rwandan law accepts them, taking into consideration the background conditions of their country of origin. Second, Congolese from DRC who are already 18 years old should be accepted to celebrate their marriage in Rwanda, whether or not they are refugees in Rwanda, as Rwandan law accepts it, taking into consideration the substantive conditions of their country of origin. 3. South Sudanese must be of the age of majority, 18 years, for their legal marriage to be performed in Rwanda, even if their customary law accepts marriage for girls in the or who has lower than 18 years in their country. This is because it takes into consideration that in Rwanda, any person in the 18 years is considered by Rwandan law as a minor. A minor cannot get married. And the marriage with a person considered as a minor is a crime. Yes, is a sin. 4. This is understandable. For Tanzanians who are 18 years old should celebrate their marriage here. The girl must be 18 years old in order not to violate Rwandan custom and the public order law, as Rwandan law recognizes anyone under 18 years old as a minor. 5. Kenyans who are already 18 years old should be accepted to perform their marriage in Rwanda, whether they are refugees in Rwanda or not, as the Rwandan law accepts it, taking into consideration the background conditions of their country of origin. 6. Ugandans can celebrate their marriage with their age recognized by their marriage age law as soon as they arrive in Rwanda. No ambiguity there, as it is 100% similar to the substantive requirement for marriage of Rwandans in Rwanda 21 years. Because to get married, if you are a Rwandan, you have to attain 21 years. So Uganda and Rwanda, no problem, because the age for marriage for get married is 21, while other countries there is some differences. This was a result of my research on marriage of East African foreigners, for marriage of East African foreigners to be celebrated. Yes, it's me. It was me, Bonipa Desiré, the Nota Think Tank founder and the CEO, Jimmy Pro manager, legal young researcher. You may have ideas, you may have different contributions, you may even support us. We need to publish many videos on our YouTube channel, the Nota Think Tank, on legal issues and also moral issue, intellectual. So I'm ready to share with you. I'm ready to discuss with you. For further discussion or sharing on of research, please contact us. Email address is this contact that you see on on here. Email address desembrimanef9 gmail.com. WhatsApp number plus 50786478575. Yes, WhatsApp is a better way to engage a conversation. Thank you very much. See you soon. I'm ready to publish other videos. Yes.